here's another big problem. Something where we have rules and conclusions but no analysis, okay? This is another one on the liability thing. It doesn't matter. Most of you guys are taking for it. You can get what the concept is here. This person is considered a business invitee. Really? That's the first sentence? That's the conclusion. Now, I understand some professors tell you to use like a CRAC type of thing where you start with the conclusion. If you're following that format, which is okay, the way you do it is this person would most likely be considered by a court to be a business invitee. Even still, you're going to use language that shows that you are aware that the answer is not a slam dunk. The answer is almost never a slam dunk in law school. Because that's the whole concept. You're supposed to be analyzing things. So if you just say, that's, you know, at the bottom of there, in this case, the duty was breached. That's it? That's it, the duty was breached, not like, you know, this would be easy for the plaintiff to prove, or this would be difficult for the plaintiff to prove. What you're supposed to be doing is predicting how the court would probably come out on a particular issue. So get comfortable with saying things like, it would pretty likely be easy for the plaintiff to prove this, or it would be more difficult for the plaintiff to prove that, or it's likely the court would find this, or it's unclear whether the court would find this.
Or best should argue that he's a business invitee.
And what my personal favorite is, the plaintiff's strongest argument is this: the plaintiff has the plaintiff will have the hardest time proving that, because center yourself around what the concept of legal writing is about. This is not a brief, okay? Legal writing, when it comes to a memo in class or a final exam, is about objectively predicting what a court would likely find. Objectively, meaning that you're going to say, I see that this is pretty likely, or this is a pretty strong case, but I do see some very real difficulties. And not downplaying them because you feel that you need to come out on one side or the other. Being clear, this is what's strong about the case, but this is what's weak about the case. Okay, here's another computer. The gas station, this is
this was great.
This typo was a car driving to the gas station, and what happened to...
Something happened at the gas station.
Somebody got hurt because something caught on fire.
Do you remember business invitee, licensee, all that? So that's what this Schwartz final exam is testing. So we have somebody...
Okay, the student is trying to analyze whether a gas station is negligent when it allowed gasoline to spill all over the concrete. Okay, that's what the student is trying to analyze.
So you get a lot of students who kind of get on a soapbox about society and what people should be comfortable doing and why things are there to serve, what purpose things are serving, which is all just a disguise for BS.
And this is, okay, the gas station is there to provide service to everyone. So it is therefore known that people will be coming on the property to utilize their services.
Any points for that? Are you giving points to that student for making this kind of conclusion? You went to law school and you learned that gas stations are there.
Yeah, they're for everyone. What the person is probably trying to do is to say, because gas stations are open to the public, a person who comes onto the gas station would likely be considered a business invitee. But that's not where this is going, and that's not what he's saying, even though he thinks he's saying that.
Yeah.
Furthermore, well, that makes it sound like you're trying to make some kind of an argument. You just told me that a gas station was there to provide service to everybody. David was at the station to receive gas, and the gas station would receive money, illustrating the mutual benefit to the parties. That's true, but why is it relevant? They never said why it's relevant. The duty, and then it goes right to, we're done with the gas station, the duty owed to an invitee. What? What's an invitee? So if we're going to talk about those facts, after that second sentence, or instead of that second sentence, it should have said, whenever a landowner stands to make money from someone who's on the land, the person on the land is considered a business invitee for purposes of deciding the duty of care. Or something to explain why those facts matter in any way to this hypo. Okay. Writing from the wrong perspective is also a problem. So this, and this is one that really gets to me when I'm reading, because it just feels so awkward. It feels like the person isn't comfortable writing at all. The gas station can defend against negligence claim by invoking the doctrine of comparative negligence. That's totally fine. If the plaintiff is found to contribute to the negligent condition and the resulting injury as great as the defendant has, then the recovery will be barred. Okay, sort of okay. leaving your car to go to the bathroom, when you are filling your car with gas, all of a sudden it shifted into this weird second person thing. That sounds like the person doesn't know how to write. It sounds unprofessional. It sounds like they're awkward, and that they know that there's something important to be said, and the person can't figure out any other way to say it but than by using the word you. And as a result, just with that grammatical problem, it creates a new problem, which is, why is that relevant? If the person had been a little stricter with language to say, oh, well, I know I can't switch back and forth from third person to second person, then instead of saying, when you do this, when you do that, when you do this, maybe the person would have chosen words that actually dovetailed the sentence before. So like, I know, I like when students ask, are they getting graded on things like grammar and spelling? You're not getting graded on grammar. But if you have bad grammar, if you use bad grammar when you're writing, half the time it actually causes legal analysis problems. And the other half of the time it just sounds like you're not as smart as you actually are. And I'll tell you, as a person who has graded lots of essays, here's how I do it. And I don't know if every professor does it like this, but I bet a lot do. I make my judgment in the first 10 seconds of reading if the person knows what they're talking about or doesn't. And if I feel that the person knows what they're talking about, then I have an A in my mind, and I just look through it to see if there's any reason to get the person down from the A. Not that I'm trying to, but is the person going to hold on to it? I'm usually rooting for the person. If the person sounds like they don't know what they're talking about in the beginning, then I start at like a C, and I look to see, is this person going to redeem themselves in some way to come up? But it's difficult if a person starts out seeming sort of dumb or uninformed or badly written or whatever it is. It's really tough to dig yourself out of that hole. And it is a snap judgment that people make about it. I mean, not that professors are trying to do that, but it's human nature. If you sound professional and polished, the professor will just like that essay better.
I just almost feel worse for the student writing this essay than I do for the encyclopedia student.
Because this person probably knew what was going on.
This is a person who is trying desperately to make a point, can't you see? They have a clear idea about the timeline of the lawsuit, or at least from the beginning to the end of the lawsuit, and what everyone's burdens would have to be, and even what a good defense would be, and in what circumstance that defense could be used. This is all what's going on in this guy's head, and because he's never practiced writing this out before, this is what you get. So had this guy practiced a little bit, had he even read this paragraph over once, he would have seen that there are a lot of mistakes. And generally, like Laura said, they're sort of superficial mistakes, especially when you're going to go switching back and forth between you and David and a landowner. All of his knowledge is getting muddled up in the execution of what he's trying to say.
Yeah, I mean, and just little things like, indenting in the beginning of a paragraph, particularly using paragraph structure is so important. Because it shows that you have a plan, and it shows that writing is something that comes naturally to you. So something that I find very interesting is that I actually find that often students who speak English as a second language do overall better than many students who are native English speakers. And I'm not really sure exactly why. I think maybe it's because they're trying harder. They're trying to compensate for this language gap, and somehow, yes, there are little things that indicate that English might not be their first language, but often the overall structure is better.
And you can tell that this person has had this argument out loud, because what's happened is
right.
The guy's like, oh, is David responsible? Well, when you go to the gas station, you don't leave the thing.
Right.
So they
That's
immediately switch conversationally into that kind of style.
Right, like I would read this and I would say, this is definitely a native English speaker who put absolutely no effort into making sure that the writing sounded refined at all. And as a professor, like certain things like this really gets to me, because a professor is going to read this and say, is this person going to write like this on a brief to a judge? And like actually get annoyed with the student for making an error that they should have known by high school not to make. Okay, using IRS, we talked about IRS before. For many students, probably not you guys because you've already been through your entire first semester and some of you through your entire first year. But some students are actually surprised to learn that when we talk about IRAC, that an exam is actually a bunch of mini IRACs. In other words, if the overall issue is whether someone is liable for battery, then there is a mini IRAC about the act, a mini IRAC about the intent, and a mini IRAC about the causation. And just keep that in mind. It should feel like a bunch of little analyses that add up to one big conclusion. Okay. Think about sub-issues. Right, every sub-issue has its own rule. We just had that. So we talked about some common errors, and we didn't do a million of them because we really want you to keep focused on the ones that are most common and most important to avoid. You got to do analysis. You can't jump straight to a conclusion. You can't be encyclopedic. You have to weave in the facts and the law. And you have to make sure that you write from a position of some finesse. It's important. You're going to be lawyers. Writing is going to be your craft. The good news is this. If you suffer through this, if you suffer through really micromanaging your writing and really looking at it under a microscope and fixing it and refining it and getting better and better, you will come out of law school having writing be something that comes very easy to you. Because legal writing is so inherently organized that if you can master that, everything else is very, very easy. And you will be asked to write things from time to time, and it will come extremely easily. Michelle and I get asked to write blog posts and magazine articles and all kinds of things all the time. And books, and in fact, we didn't bring a copy of our other book. We have another book that's about 150 pages. It's a small book. It's called How to Talk to Your Lawyer. And it's meant for clients who, want to sort of take control over their attorney if they feel being taken advantage of. But it's also sort of a handbook about how to be a good client, not torture your attorney. So it's like a very kind of even-handed book. But I bring it up to say, this was very funny though. Someone asked us to write a book. A publisher asked us to write a book. So we said, all right, we'll write a book. We checked into a hotel. We stayed there for a day and a half, and we wrote the book. And it's a 200-page book. And it's a great book. It's fun. It's cute. But it was so easy compared to doing this, that once you can master this, like, you really will be able to use words to do anything. And given that so many jobs are so focused on writing, even if you choose not to practice law, you will have a skill that is totally translatable and transferable to anything you do when you're done.
I sometimes tell students the more you write, the more you read, the better you'll write. When you start to read a bunch of these cases for whatever your upper class writing assignment might be, it might be moot court, it might be your note for law review. The more of these kinds of cases you read, the more you see that somehow they fall out into the CRUG or IRAC pattern.
Mm-hmm.
What begins
And it sounds
to
like the
happen,
same guy wrote all of them.
What?
It
It
always
sounds
feels
like the same guy wrote all of them, right? And it's not the same guy. It's not even the same guy from the same place.
It's not even always a guy.
Right? So what begins to happen is you begin to see that this is actually how you write clearly. It's about getting your point across and telling a specific story to someone that's trying to learn something from the behavior of the people from this case. So what you're actually doing when you're writing this or a final exam is you're actually unfolding something step by step by step. Give yourself the time and have patience with yourself to be able to unfold what it is that you're trying to say. A lot of these answers were very rushed. You feel a lot of the nervousness coming off the page from the student who's just trying to get the answer out there. That's no way to convey anything. And I'll tell you that once you get through law school and you have just put yourself through this experience, which is somewhat painful, very grueling, you'll have zero patience for anyone who can't do it.
Yep.
You'll meet a person, they'll have some story to tell you, and they'll sit in your office for 15 minutes and you'll have no idea what the hell they're talking about. And what happens is you'll begin to understand exactly what it means to get to the point immediately and pull out of the story exactly what you want. And that's all your professor wants from you. I had a client call me up, he had a divorce question. Okay, they all had these questions. And his question was preceded by 15 minutes of his explaining to me how crazy his wife was. There was no question in that 15 minutes. I have a question for you. Okay, what's your question? My wife is crazy. That's not a question. She had an affair. Still not a question. She's been on medication for 100 years. Still not a question. On and on and on and on and on. All this irrelevant information that he thinks somehow is relevant. What is the legal question? Is that going to help me in my divorce? Not really. That's the answer. And I could have hung up on him by then. The point is that you want to be able to unfold your information in a way that is important, relevant, conveys that you know something in an intelligent way, in a patient way, in a way that conveys that you know the subject matter, you're comfortable with it, you have a facility with the language involved with it, okay? okay? And you get that through practice.
I just want to piggyback on that. It's so important because having a break, you were talking about the lazy brain, and professors have a lazy brain. And I know if I see someone writing out, this is the issue, this is the rule, you underline, these are the 4 elements, I can just check that person's answer and go to the next one. But if you have to read this blob, this mess, where lines going to this part of the question and lines going over here, like we talked about human nature.
Yeah.
Somehow something in me is going to want to punish.
Yeah, yeah,
Right.
yeah, absolutely.
And I'm sure my professors, I have messy handwriting. I have it to this day. And so I've probably been punished as well.
You're not being respectful to your reader.
And I'll tell you this, handwriting is actually a really interesting point. When Michelle and I went to law school, all exams were handwritten. Most law schools now, most exams are typed. Are your exams typed or handwritten? Typed. Now, I will say this, typing is a wonderful tool because if you are a good typist, you can get a lot more in. And I remember being furious that some schools had typed exams because I could have written 10 times more if I typed it than in versus handwriting. However, be aware of the one peril of typed exams. When looking at a printed word, human nature is to forget that it's not professional. And when you're typing, the errors are actually more obvious to the person grading. Okay, so here's our plan. The writing exercises that you did, we would like to have you read them to everybody. We're all friends. And we're not going to tear you apart, I totally promise, okay?
Well, you kind of want us to, right? Better we tell you apart than your professor. I don't have
But
to.
we're not going to be mean about it, no. And actually, I think we're gonna let each other contribute to it. So do we have any volunteers? Come on, you're all gonna do it.
I'm going to pick then.
You can pick one of my people.
One of my people.
Okay.
I want to hear about the relationship of character evidence to mimic.
Okay, now here's the thing. So my guys haven't taken evidence yet, which is why you're the perfect audience for this. Because you're smart, you understand law, but you haven't done this topic yet. So, I forgot her name. Okay. So our evidence girl, what's her name? Noelle. Noelle's essay about character evidence and mimic should explain everything, okay? Should explain in a way that even someone who hasn't taken the subject could basically digest.
So maybe you guys want to take some notes if you have any questions. I mean, help Noelle out. Help Noelle be a better writer, be an active listener, and jot down what you feel was done well, and maybe what you feel was missing.
Now, before you start, Noelle, the only primer information that you need to know about evidence is that the overall issue in every single evidence thing is, does whatever this information is get in or not get in? Is it admissible or inadmissible? And Noelle's talking about mimic, you said? Okay. Character evidence, just so that you understand what it is. Character evidence is evidence, whether it's oral testimony, written testimony, document, whatever kind of physical testimony, but it's some kind of evidence that relates to whether a person is a nice guy, or whether the person has done nice things in the past, or done mean things in the past. That is what we mean by the phrase character evidence. Evidence about kind of how somebody lives or what they've done.
Generally, we don't allow that. That might be right. Well, just so that you wrap your head around. Generally, we don't allow that kind of evidence to be admissible into court, because whether you're a bad dude does not necessarily mean that you committed a certain crime or a good guy.
Right, and like,
Okay.
just
It's
because
not
you
relevant.
one time ran over a kitten doesn't mean you're a terrible person and did everything wrong.
Right.
And
Or
just
a pit
because,
bull.
right, and just because you donated money to a charity one time doesn't mean you've done the nice thing.
You're a
every
great
time.
guy, right? Okay.
Okay, here's Noelle.
Character evidence is generally excluded from admissibility under the rules of evidence.
Beautiful.
Rule 404 bars the entry of evidence related to a party or witness's character. The reason why character evidence is barred is because it may be likely to create bias or prejudice in the minds of jury members. For example, character evidence that a party or witness is anti-Semitic would be barred if introduced indirect under Rule 403 and 404 because in a case dealing with a violent hate crime, this will likely create bias in the minds of jury members. Therefore, character evidence is not admissible. However, there are exceptions, and this is in the paragraph.
I'm just gonna stop you for 1 second. So far, I think it's great, just really quick. The reason why Noelle's writing sounds like very book reporty and encyclopedic is not because she made a mistake. It's because she's writing a kind of writing exercise that does not have a hypo. It's just an explanatory hypo.
We call this book report style. We tell our students to write book report style essays on topics that they already know.
For practice.
For practice. Okay?
Okay, so sorry.
However, there are exceptions to this general restriction. Under Rule 404, character evidence may be admitted to prove modus operandi, identity, absence of mistake, intent, or common plan or scheme. This exception exists to allow for the admission of evidence which has an independent basis for admission. Put another way, evidence which looks like character evidence may be admitted to prove modus operandi, identity, absence of mistake, intent, or common plan, common plan or scheme, because it has a standalone basis in relevance and probity to prove not that the party/witness acted in accordance with the character evidence, but rather that the party/witness is the type of person that would commit the act complained of, because the evidence offered complained of, period. No, it's not. Because
Let me just
Oh,
say,
you
I
said
love
it
that
together.
sentence. So did I. I just feel like the sentence that preceded that one was not necessary in light of the fact that the secondary sentence was so much more superior.
It was a great, and I just wanted, so your sentence said, you have such a beautiful voice, by the way, I have to just tell you. Like, you should be like a DJ, it's very soothing. So what you said, Noelle is describing the relationship between this particular rule called the mimic rule and its general character evidence. And what she's saying is generally you don't let character evidence in, but sometimes if there's an independent reason, we do let it in. And I'm sorry, just read that one sentence again. There was something in there I wanted to comment on.
the last one,
Yeah.
put another way, evidence which looks like character evidence.
Right, okay, now that sentence I thought was so well written. And I would want to just, and I'm bringing it to your attention, just so that if you did have a hypo, okay, that you could convert that into a proper exam sentence, right? Where you might say, even though the evidence that Joe stepped on somebody's toe in 3rd grade seems like character evidence, it could be converted into mimic evidence for blah, blah, blah. And what you have there, even though you were not working with a hypo, is you do have the kind of transitions that could be used on an exam. You have your thoughts that you want to get across. You did a beautiful job describing the law. Your only other step would be to then blend what you know from that in that organized way with facts that apply to your hypo. But I thought it was actually really great.
Me too.
I'm not even letting anybody, it was too good.
Yeah.
So I want to hear from somebody, one of my guys.
You could actually, I just want to say this, you could actually take that, keep it, hold it, and start now taking final exam essay questions and use this tool that you now have to answer questions about character evidence. That essay, that put another way sentence,
Yeah.
should be put the only way. And that should be the basis of the essay answer for character evidence.
And the other thing is,
And I say
Mimic.
basis only because you're going to put the facts on top of it, okay?
and just FYI, like, I don't know if you know this already, but mimic will absolutely be the basis of potentially an essay question, but at least 5 multiple choice questions. So it's something that is extremely highly tested.
I want to point out the conversational tone of the writing,
Yeah.
the level of comfort she has with the material.
The fact that there's a variation in the sentence structure, each sentence has a different structure from the one preceding it, that's important to make it sound really good.
Did that come through to you guys? Did you understand what her overall point was? Yeah?
Sounds good.
Sounded good.
Sounded right.
Didn't sound really nice. Didn't sound clumsy.
Yeah, no, it
Okay?
did sound clumsy.
Good job. I give you a
Okay.
10.
Now, Mauricio is going to go next. It's all good, it's fine, okay. But let me just tell the group, though, what our hypo is. We're learning about equal protection, so you guys have all taken some already, right? Or all except one are taking some. And our hypo was a very simple hypo. It was that a state made a law that said a child who has 2 obese parents, any child that has 2 obese parents, has to go for mandatory nutrition counseling to solve the problem of childhood obesity. Now, we have a fake law on the table, and that fake law is a law that says, kid, 2 fat parents, the kid has to go to nutritional training. So what's the first thing that you would have?
Okay, well, I just wrote, the state may have created an unconstitutional legislation with its mandate.
Beautiful.
Any child who has 2 parents who are both obese must attend
Anybody have a problem with that as a starting sentence?
I like it.
I love it, because the first thing you said is may, to say may, and you said what the issue was. May have created an unconstitutional law.
And you incorporated facts too.
Yeah, you incorporated facts,
You
sounds
did
great.
everything that you were supposed to do. Go ahead.
And then this is the part, I guess I just wrote notes on the side.
This is also gonna be terrible. Okay, let's go.
I wasn't sure, like, you know, you said like there was due protection and then there was also equal.
There's due
well,
process and
and
equal protection,
equal. So I was gonna.
Oh, you didn't know. Okay, so you're a terrible writer and you also
I
don't.
don't know.
Okay. All right.
Okay.
So what did you do?
I mean, I just wrote on the side, like, this is where I would, discuss it.
If it's one or the other, okay, and I'll tell you that the exercise was made to be equal protection, and the reason why, it could be due process also, many laws could be challenged both ways. To challenge it under equal protection, the challenger would have to say, the law treats different groups of people differently. Here, the group is kids with fat parents versus the rest of the world, right? So let's go through it as an equal protection challenge, okay? So what's the first step in your equal protection analysis?
Well, I mean, that's considering I didn't.
Oh, wait.
um,
Look up. What's the first thing you have to figure out?
what class is that?
You have to figure out what class the law creates, okay?
So who do we got? What do we got?
Is it a race classification?
Well, I mean, I did get into that.
Go ahead.
later on.
Okay. Well, tell me.
Did I just continue?
Of course.
A child who has two parents who are obese could be considered to be a protected member of a quasi-suspect class, in which case the state's policy would be subject to intermediate scrutiny.
Okay, I love the sentence. Writing-wise, I love it. On the law, it's not
I don't
really
think so.
100% right.
Wait, I don't think so. Could the child help that his parents are obese? Make the argument.
Well, okay, let's see. Go ahead, tell me, who knows? The writing is, from a writing standpoint and a structure standpoint, perfect.
This statute seems to infringe upon an individual's fundamental rights of privacy.
Okay, now that's due process. Fundamental rights is due process, groups is equal protection.
Well, I think I ended up doing more so.
Okay, which is fine. It's not, due process is not wrong, because it could be either way. So go ahead, tell me what else.
It seeks to separate children with two obese parents from those who may have one parent.
I didn't even think of that when I made up the hypo. That's awesome. I did not even think of that. That's totally not why I made it kids with parents. You're right. I didn't even think of that.
And then,
So you had a great sentence before, which is, if this is found to be a quasi-suspect class, then it's going to get intermediate scrutiny. What comes next?
separate children from two others from those who have one parent and those who may have parents who simply aren't.
Okay.
The statute is discriminatory in regards to legitimacy on its face. On the other hand, the state could argue that childhood obesity is an important interest and that the law was construed narrowly as not to subject the entire class of people to this abuse.
Okay. You're like, I mean, you haven't even taken this subject in class yet, right? You haven't even done it. You're doing like an outstanding job for somebody that has.
Do you know when the professor says to you, like, dazzle me, like, show me something I didn't imagine? Do you ever have the professor say that? Like, give me something that that's totally unexpected. That's totally unexpected. Where you took, you took something that, you picked up on something that we didn't expect you to pick up on. But others that are there because they can't help who they are. In other words, they're females, that's how they were born, so they can't help it. They're illegitimate, that's how they were born, so they can't help it. So children who were born of two fat parents, that's how they are, they can't help it. But you differentiated between two parents and one parent to make them illegitimate, to put them in that class.
Yeah, and you're like, there's a way you could look at it that they would get. And I think that's great.
Twisting, like not twisting, but making the facts say what you want them to say so that you can make the legal argument is very important to legal writing.
Particularly in the classic constitutional law. The one thing I would say, though, is the more obvious analysis, like I would have said, I love what you said, I would have said it second. What should have been first is, at a minimum, it's going to be a non-suspect class, because obviously it's not about race. And it could easily be, kids with fat parents, everybody else. That's a non-suspect class, and that gets rational basis. That's, you said it later on, that's fine, that's fine. That's fine. The other critique I would have is, you started to become unclear about what difference it makes which class the person falls into. When you first talked about it, you said, and then it would get intermediate scrutiny. But then I don't think you said what it means for a law to require intermediate scrutiny. And then after you say what it means, the next step is actually seeing if the law passes that scrutiny. Now, you haven't even done this in class, and you haven't even read any of these cases. So I really would not expect you to be able to do much more than that. But
Just so that you know.
just so that you know, like
You're
it's,
telling me that this is the test that this law must go through, but then you have to put the law through the test. Okay, just like the international shoe situation.
I think
Yeah?
I think that was a great
But
job.
that's great. So again, like what we want you to leave with is a tool and a good place to start. And I really, really think that you're there. You know, you're at a very, very good place to start. And I love the way you're thinking, and I love your analysis.
Well, in regards to structure, 'cause I had this issue with my criminal law professor. She kind of felt that, I mean, when I met with her, she said the same thing, like, you know, there were some obvious points that I felt like you did that at the end instead of doing that first.
Okay.
But the way that my mind was thinking the criminal law exam was like more, how did things happen in the fact pattern? I wrote my essay based on a time.
Oh, that's interesting, like
And-
chronologically
and
kind of.
here, the way that I did, I started with the higher scrutiny and then went back to say, right?
In general, legal writing should be done like this. You prioritize based on strength. So the strongest, most likely thing to succeed goes first. And then
The
the one,
easiest thing to prove. in
the
other words.
easiest thing to prove goes first. And
Then the more difficult thing that comes next, or whatever takes the more creative legal analysis, like what you did to force them to be in intermediate scrutiny, that will come next. Not because it's not as important, it's just that get the easy stuff out first. Just like what the judges here do. They go, look, you know, the guy's guilty of a robbery, but that's obvious, we're going to put that right out there. That's done. Now I got your attention, let's get into the more creative writing. You understand? So don't, in college, we saved our best argument for last. You remember that in college?
yeah, you never do
We
that.
don't do that in law school. We show off right away. We step up and we're like, the guy's a goner. Okay, right away. Okay, and then you can show off and dazzle your professor with a little bit more of the more
Okay, I
creative
didn't
stuff.
know that there was like I mean, my intention wasn't to dazzle anybody, actually.
Well, now it should be.
It was just that, you know, the way that I guess my mind works, intermediate is here, rational basis is here, so
Right.
I'm gonna go.
Oh, so that's like the order of the
That's
test.
like-
Right, that's a good point. No, you
But
do
don't do
what's a
that.
slam dunk first. And typically, the big issues on a law school exam I think of it as like a three-tiered approach. There's always one argument that's obvious. Then there's one that's not obvious, but is very likely. Like there's like the one that's going to almost definitely succeed. Then there's a good counter argument. It's good. It's not going to win, but it's a good argument. And then there's one that's like weird and creative and unlikely to ever succeed, but you never know.
So like the thing is that because you want to be able to tell the professor about what you know, you want to be able to tell the professor, I know about suspect class, I know about quasi-suspect class, I know about rational basis, and I know all of the rules and language that go along with each test. Because you want to be able to do that, what you do is you choose which one applies to your fact pattern. That's the slam dunk, that's the point getter, right? Once you're done with that, then you sit back and you figure out how you're going to talk about the other two that don't apply. And you just become creative there, and you force it to apply. If you get your back up against the wall and you're like, there is just no way that this applies, if it's the Omaha microphone law, and there's no way it's going to be suspect class, tell the professor. This does not have to do with any fundamental right. This has got nothing to do with classification based on race. This is not a suspect classification. Tell the professor that. But you said slam dunk, so I started thinking about basketball, and I just want to say this one more thing. With essay writing, you want to get as many points as you possibly can quickly, so that later on you can slam dunk and show off. Okay? So put your point-getting stuff out there fast, and then start showing off. Okay? That's the way you want to play it. Okay. I want to hear about the business judgment rule. So, like, we didn't deal with typos. We just are writing in our teams from the book report style, okay? So we're learning about corporations over here. And I know it might sound very boring, but sometimes when the head honchos in corporations screw up, they have a net, a safety net, to help them out. They have a very important role and a very important relationship to their corporation, but sometimes when they screw up, they have a safety net. Oh, and by the way, if I haven't recommended Too Big to Fail, watch Too Big to Fail. Okay, go ahead.
Under the NCBA, the board of directors of a company is empowered to make decisions to direct the business of the company. Although the board can make business decisions on behalf of the company, the wisdom of those decisions can be challenged by company shareholders. When shareholders challenge the wisdom of a particular business decision, the board is protected by an assumption that their decision is ultimately in the best interest of the company. This assumption is called the business judgment. In effect, the business judgment rule defers to the board's judgment because board members have particularized knowledge and experience about a particular field.
I'm so dazzled right now.
Yeah, you're a great writer.
You know what I like? I like that it's unfolding bit by bit. So you start off with a big general idea, and now you're focusing
And you guys
very
who haven't taken
slowly.
corporations, you can follow what he's saying, right?
See, there's that patience I'm talking about, right there. That's what I'm getting from you right now.
Okay. I lost my thought.
Sorry.
Okay.
This is called a business judgment rule. That was the last thing you said.
Okay, so this is called the business judgment rule. The business judgment rule defers to the board's judgment. Board members have particularized knowledge and were hired to make business decisions because of their accomplishments.
That sentence, kid, replace the sentence before it and vice versa. You're just repeating yourself.
What I don't like about that sentence, as much as it sounds nice and it's correct, what I don't like about it is that it's going off on sort of a tangent where it's getting away from the purpose of the business judgment rule, and it's instead talking about the reason why we have the business judgment rule.
Okay.
Up until that sentence, everything that you had written could be replaced with facts from a hypo easily, because you would be talking about this is what it's going to do and this is why it's relevant, but you would not, you usually, like on a real essay, you probably wouldn't talk about why we have it all that much. But other than that,
And up until that point,
I'm
each
splitting hairs
sentence,
though, really.
yeah, we really
It's a really minor criticism.
each sentence was advancing the point further.
Yeah.
Those two sentences, just like Laura said, go kind of off on a tangent. The first sentence introduced an idea, the second then just took it a little bit too far off the point.
Okay.
We're talking about the business judgment rule
And what it does.
and what it does. Okay, go ahead.
Okay. Therefore, a court will usually defer to the business decisions made by the board because courts lack the equivalent amount of knowledge and
Important,
experience.
very good.
Good.
However, the business judgment rule does not give the board its power to make business decisions. Likewise, the rule does not permit the board to make any decision. Courts only protect the board with the business judgment rule when the court believes the board acted to benefit the company. As such, there are times when the business judgment rule cannot afford board decisions any protection.
There's just one thing that I'm like thirsting for as you're reading this, which is you told us what the business judgment rule is, and now you're about to tell us that there are a few times that the court doesn't use it. You never really said how it functions. You never really said what it does. Like the business
It protects.
it protects. Like in what
what
way does it
circumstance?
protect? Like how does it protect?
Oh,
I'm
okay.
waiting for you to get there. I know you're going to get there. I'm just
Oh, you're
waiting
gonna
for
get
you
there later?
I think so.
Okay. Sentence structure is just beyond belief.
Yeah. Sentence structures are awesome.
The sentence that said started with as such, just,
It takes
I don't
a
know, it did.
Okay. There are three instances when the board's decisions are not protected by the business judgment rule. When the board does not act in good faith, when the board does not use the appropriate care in making their decisions, and when the board decision is disloyal to the interests of the company. If any of these situations occur, the court will conclude that the board breached their fiduciary duty to the company, and courts will apply heightened scrutiny when examining board decisions. The duties a board is usually required to abide by are 1, the duty of good faith, 2, the duty of care, and 3, the duty of loyalty.
I'm going to stop you there just for 1 second. That sentence, not relevant to the business judgment rule. Totally true. A little general. If I were going to use that sentence, I would have used it earlier. But I don't know that I would choose to use it at all in a discussion of the business judgment rule, because that's only the business judgment rule is a defense to a duty of care lawsuit. And it doesn't have really, not that it has nothing to do with the duty of loyalty, but like that concept came sort of from left field it wasn't necessary to explain where you were going. But otherwise, it was correct, though.
I want to say that for somebody who knows about corporations and who has taught it, like me or your professor, what I'm finding myself doing is completing your sentences, which is great because that means that I know exactly where you're going, and then you go there.
Yeah.
So it's expected. It's not. I'm excited about the next thing that you're about to say because it's what I want you to say. In other words.
Okay.
Okay. So good job.
Okay. Now, before I continue, you said that the business judgment rule is only a defense to the duty of care. Because I was confused and I thought it was a defense I thought it could be used in any time a suit was brought. You'd have to prove good faith or what have you. And essentially,
Like if a director got sued for a breach of the duty of loyalty, saying that he was doing things under the business judgment rule wouldn't save him. The business judgment rule is like when you make a decision that seems like it's a good idea at the time and it turns out to be a bad decision, but that's essentially a breach of the duty of care lawsuit,
okay.
right?
I don't want us to waste too much time. I feel like
Okay.
you're doing a great job. I don't need to hear anymore.
Okay.
I think you're doing a fantastic job. The sentence, like I said, sentence structure is great. Each sentence is just easily following the next. So much so that when one sentence goes off, I'm aware. You
Right,
understand?
that's why we're like really nitpicking it.
Right.
Because it's
Because
overall
it's
very
so
good.
flowy. It's one sentence is just easily flowing so much into the next one that when one goes off track, it's wildly obvious. And I feel like if you just practice that exact essay 2 more times, you'd have it pitch perfect.
And if you take that kind of knowledge and concept and you bring it to the hypo, I'm sure the answer
Yeah.
is great.
Okay, so
We're gonna do one of my other questions.
oh, that's right.
Yeah, so this is rational basis. So I just said this law discriminates based on weight, which is a non-suspect class, so the rational basis test will apply.
Nice.
Obesity,
The one thing I would just say is that I would more likely say it's most likely going to be considered a non-suspect class. I don't know that I would just conclude right off the bat. It's
You want to be a little bit more wishy-washy with your opening
just
statement.
a little bit.
okay. Obesity can be irrationally related to legitimate state interests. Because obesity leads to health problems and higher health insurance premiums, which if the state is offering health insurance to children under their CHIPS program, this would be a legitimate state concern.
Okay.
The law has to be rationally
Yeah.
related, not obesity, not the fat kids.
The
Right.
law has
The
to
law
be
has to-
rationally related.
I know that's what you meant. This is
Okay.
this is a good example of say what you mean.
Okay.
Okay, you didn't say what you meant. I know what you meant, but you're not going to get points for that, and that's the difference between the A and the B. See what I'm saying?
Yeah.
I know exactly what you meant, and the professor's got to draw a line somewhere between the kid who said obesity and the kid who said the obesity law.
Okay.
Okay, don't be on the wrong side of that line.
Okay. This law does not appear to be arbitrary or irrational. Obesity could lead to underperformance at school, which is also could be considered a compelling state interest if a child is of compulsory age.
All right, I know you also haven't studied this yet in class. Just for your further knowledge, the way that it works is that the state has to be trying to accomplish something with the law. The thing that the state is trying to accomplish, that's the state interest. So the state interest would be like preventing obesity, fixing health problems, fixing nutrition. Like it would have, you have to. It's the thing that the state is trying to do that has
So
that
what
interest.
you're doing is you're telling the reader, this is the problem that the state is trying to fix with the law. Just say that and then go ahead and move on.
So I should have just said like,
Fat people are a problem.
they're trying to fix obesity because it can lead to underperformance.
No, I don't care why they're trying to fix it. Fixing obesity
Is what they're
is
trying to
most
do.
likely, here's the way I would say it so that you can understand. Most likely, a court would find that preventing obesity, especially in children, is a legitimate state interest.
Okay.
Most likely, a court would find that because it's a health-related issue, and most likely, a court would consider that to be a legitimate interest. It's not trying to hurt anyone, it's not trying to take rights away from anyone, it's just trying to fix a health
So
problem.
what we're trying to tell you is, when you're thinking about the law, think about the law's relationship to this test, okay? Don't worry so much about what the law is. It doesn't really exist. Again, the fat people don't exist, the fat kids don't exist, their parents don't exist, nobody exists. So what we just want to know is, the laws about obesity, is the law rationally related to some interest? The interest is making sure there's less fat people. Okay, that's good. You don't have to go on and on about why fat people are bad for the state. Okay? Okay, go ahead.
On the other hand, this law doesn't capture children who are obese who only know one obese parent, who have an obese parent who is deceased, or do not have either parent alive, but both parents were obese.
Oh, spectacular, I have to say, I really wasn't even thinking that at all when we talked about HIPO. Spectacular place for your mind to go. Spectacular idea for analysis. I worry about one little thing, which is that what you're doing is you're making this great counter argument about something that's not quite right about the law. And what you're saying is that potentially it's over-inclusive or under-inclusive, and that's like definitely a problem. The only thing that's really killing me about it is that you didn't say why that matters. You didn't, or maybe you will say why it matters.
Oh, I said so therefore the law seems arbitrary to treat
Okay.
two obese parent households different than
Gotcha.
addressing
Gotcha.
child obesity
Now-
more generally.
Still good. Concept, perfect.
It
Okay?
really shows that you understand how the rule works.
The only thing that I would say is you will get more points out of saying exactly what you said in this way. It is possible that a court would find that the law is not rationally related, or that the law fails the rational basis test because, and then say what those facts are.
Understand that the one critique so far overall is say exactly what you're saying. Don't come down so hard on one side, and replace all of your this is with this may be.
That, and then
Will
also,
the court might.
and when you're doing your analysis, you need to be clearer, not clearer, but clear more upfront.
Okay.
In other words, this might not work. Why? Because of blah, blah, blah. So you had the reasons why, and then you led up to this like conclusion of, so because of all that, drum roll, here's what it's gonna mean. What I want is, this might happen, and here's support. So just flip that a little bit. Instead of being reason, drum roll, conclusion, what you want is, the point I'm trying to make, reasons or support. I think it would help a lot, because I love where you're going with it. And the writing really isn't the problem, it's more of the concept of the writing, that's the problem. Okay, good job, great. Okay,
We only have time for one more, so who wants to go? We have adverse possession, we have hearsay. All right, let's hear a little bit of adverse possession.
Okay, issues who is the rightful owner of the property. Looper, because bail afterwards.
Oh wait, finally we have somebody that has a hypothetical. This is all Andrew knows.
Okay, this is an adverse possession hypothetical, where,
You guys have it in your materials.
oh yeah, and what, remind me what this?
Is this remind me what the hypo is. Is it fuel nose? I don't know.
The owner, the owner has big property, then
This is
one
when they
guy
built the house
passing
and it was green and it was
in,
kind of fun.
kind of like the property, we start living.
Remind me, 'cause I can't remember what it.
So true owner,
It's the
right,
family
in
that
Rosalind, Kentuckian, right, okay, so a family comes over and builds a house on the landowner's property. Remember, you guys remember adverse possession?
So they're in property right now, right? Did you do adverse possession yet?
Okay, they build a house and the house is like a few feet in from the main road. It's green, just like the forest. And people have been living there for 25 years. Okay? And the hypo is on page 30. Okay, go ahead, hit it. Start from the beginning.
Okay, issues the rightful owner of the property. Loopers, because the bail afterwards, or
True owner.
True owner. Because the adverse position, the first pastor has to actually possess property continuously for the certain period of without permission from the true owner, openly and exclusively.
Okay, so I want to hear about the Lopers and how long they've been there and what they have to prove in order to show that they're the rightful owners and not true owner.
Yeah, it's very important to use the phrase, the person's name would need to prove. That's so helpful. It gets you started on the right track from the very beginning. This person would need to prove X in order to accomplish Y. Okay, go ahead. A little bit more.
First element, the phrase possibility group is a continuous use. First, continuous use means that a reasonable person would use the property continuous. Depending on the type of the use, intermediate use may constitute continuous use if reasonable person.
I'm going to stop you there.
Yeah.
It seems like you're writing like the encyclopedia. Remember the encyclopedia person that we outlined over here? Where you're giving me exactly what the law is, but you're not showing me that you understand what the law is. So you're just restating what the rule is, but what your professor